The United States Supreme Court is circling the wagons to try to protect the Federal Reserve. It's the second major organization that's pushed back on Donald Trump, telling him, you may fire everybody in sight in the federal government, but stay off of the Federal Reserve, which probably calmed financial markets, which are hoping that Donald Trump doesn't go completely cuckoo crazy and fire Jay Powell. Got a new decision, had nothing to do with the Federal Reserve, but even the majority in a 6-3 decision decided we better warn Donald Trump that she's basically hands off when it comes to Jay Powell and our central bank. The case had to do with the National Labor Relations Board and the Merit Service Protection Board. And you know what Donald Trump just did that nobody's talking about? He lopped off 2 members of each place, the Merit Service Protection Board and the National Labor Relations Board, creating a situation where they don't have a quorum and they can't operate. Nobody talked about it. I'm going to talk about it right here on Legal AF. That's what Donald Trump did. He just put into suspended animation. He just put on ice 2 major organizations that have been around since the 1930s to protect federal workers and labor unions, and they were just put out of business and nobody said a word about it at the United States Supreme Court. Let's get into it. Michael Popok, Legal AF. The case is technically called Trump v. Wilcox. The 1930s, during a lot of labor strife, and to protect federal workers from being fired unilaterally for partisan reasons, and to protect union workers out there, a lot of them who supported Donald Trump, the Congress created 2 executive agencies, bipartisan, independent agencies, National Labor Relations Board and Merit Service Protection Board. They have 3 members on the the Merit Service Protection Board, 5 members on the National Labor Relations Board. There's rules and regulations about how many Republicans you can have on there, how many Democrats, and most importantly, you can't fire people if you're the president unless you have cause, because they didn't want to make these partisan. They wanted to make these independent. And there's a law from 1935 called Humphrey's Executor. You'll hear a lot about it on this hot take. It's just the name of a case. A guy named Humphreys got fired in 1933 by FDR, and he was on the Federal Trade Commission, and he fought to get his job back. And the Supreme Court ruled in Humphrey's Executor in 1935 that if you're on an agency created by Congress and it's sort of independent and bipartisan for a certain purpose, and it doesn't wield a lot of executive power but has a lot of expertise in a certain area, the president can fire people, but only for cause. You can't just fire them because you don't like the color of their party. And so that's been the law of the land, although the Supreme Court has been chipping away and the right wing hates it because they want to give all the power to the executive branch and they want to take it away from Congress. And so basically they've just declared in a new ruling, at least for now, until full briefing at some other point in a year from now, that for now, whenever Congress makes a executive branch agency, the executive branch head, which is the president, can do whatever he wants with it, regardless of what Congress says, regardless of what Congress says in the statute. You can disregard all that. Once they create it and give birth to it and turn it over for the president to raise, they have no right to talk about what happens to that child. That's one way of putting it. So we get the ruling. It's 10 pages. And it basically says on its face that Donald Trump and any president has the power to fire at will for no cause at all anybody that he sees fits. Now, why did Donald Trump want to do this? Because it's an easy way to put out of business the Merit Service Protection Board, which governs federal workers who have disputes like they're being retaliated against, and whistleblower protection, and the National Labor Relations Board, which big business hates because it gives rights to labor unions and organized workers. And Donald Trump just put them out of business. How? Because in order to operate, you got to have a quorum. And by firing Kathy Harris from the Merit Service Protection Board and Gwen Wilcox from the National Labor Relations Board, there's no more quorum at either place. They've only got 1 member left of the Merit Service Protection Board. There's supposed to be 3. There's only 2 members left at the National Labor Relations Board. There's supposed to be 5 total, at least 3 for quorum. They're done. Nobody talked about it in the briefing. I need to talk about it here. Donald Trump hates labor unions, hates workers, even if they're American voters. And I can't believe any labor union even supported Donald Trump at all. Now, here's the part about the Federal Reserve. Didn't even come up. I mean, it was argued that if Donald Trump can pull out a sledgehammer and get rid of the NLRB and the Merit Service Protection Board. He could also go after the Federal Trade Commission. He could go after the central bank and the Federal Reserve. And we know Donald Trump hates Jay Powell. But the Supreme Court, which has its own stock portfolio, I'm sure, and worried about Donald Trump cutting the fuel line and the umbilical cord between the American economy and planet Earth by getting rid of Jay Powell, they decided we better put a ring fence and protect Jay Powell. And it's the second major organization that's done it. Earlier, about a week or so ago, Moody's, a major rating agency, in downgrading the U.S. debt, basically downgrading the American credit score for the first time since 1917, World War I, said one of the major reasons we're going to cut it is because of the instability in the economy under Donald Trump. And they said, and they warned Donald Trump, they said, we're going to leave the credit rating now below AAA down to something else. We may cut it again if you touch the Federal Reserve. If you touch the independence of the Federal Reserve, we're going to downgrade your debt again, making it more expensive for us to borrow money and have to raise treasury rates and the rest. Supreme Court decided out of the blue to also put a fence around Jay Powell. Here's what they said. On page 2, respondents Gwen Wilcox and Kathy Harris contend that arguments in this case necessarily implicate the constitutionality of for-cause removal protections for the Federal Reserve, the Federal Open Market Committee, and basically the Federal Reserve, which is the central bank for America, and Jay Powell heads it. Here's what they said about that. The Federal Reserve is a uniquely structured quasi-private entity that follows in this distinct historical tradition of the first and second banks of the United States. Therefore, they're not like you, and they can't be fired without cause. That was sort of out of the blue. That was so shocking that Justice Kagan, writing with Sotomayor and Jackson in dissent, in a scathing dissent, said the following in her decision. She said as follows. In valuing so highly, this is on page 7 of her dissent, in valuing so highly in an emergency posture the president's ability to fire without cause the head of the Merit Service Protection Board and the NLRB, the majority all but declares Humphrey's executor, that case I told you about, itself the emergency, except apparently for the Federal Reserve. The majority closes today's order by stating, out of the blue, this is Kagan writing, that it has no bearing on the constitutionality of a for-cause removal protections for members of the Federal Reserve Board or Open Market Committee. I'm glad to hear it, Kagan wrote, and no doubt, and do not doubt the majority's intention to avoid imperiling the Fed. But then today's order poses a puzzle. For the Federal Reserve's independence rests on the same constitutional and analytic foundations as that of the NLRB, the Merit Service Protection Board, the Federal Trade Commission, the Federal Communications Commission, and so on, which is to say it rests largely on Humphrey's executor, the case they just effectively overruled. So the majority has to offer a different story. This is Kagan writing for the dissent. The Federal Reserve, it submits, is a uniquely structured entity that with a distinct historical tradition. And it cites for that proposition a footnote from a case of theirs from 2020 called Celia Law. But sorry, Kagan writes, footnote 8 provides no support. Its only relevant sentence rejects an argument made in the dissenting opinion, even assuming that financial institutions like the Second Bank and Federal Reserve can claim a special historical status. And so an assumption made to humor a dissent gets turned into some kind of holding. Because one way of making new law on the emergency docket, the deprecation of Humphrey, she writes, turns out to require yet another, the creation of a bespoke Federal Reserve exemption. If the idea is to reassure the markets, Kagan writes, a simpler and more judicial approach would have been to deny the president's application for a stay on the continued authority of Humphreys. And then she quotes the Federalist Papers, and she says, to avoid and Hamilton effectively, to avoid an arbitrary discretion in the courts, Hamilton wrote, it is indispensable that they should be bound down by strict rules in precedents. Today's order, Kagan wrote, however, favors the president over our precedent, and it does so unrestrained by the rules of briefing and argument and the passage of time needed to discipline our decision-making. powerful things from Justice Kagan and setting us all straight on what we just observed at the United States Supreme Court. So I'm going to continue to follow. What's the next steps? They're saying, well, we'll take full briefing. In the meantime, Wilcox and Humphreys, you're out of a job. Maybe we'll give you your job back in a year, but don't count on it because of the way we look at these agencies as being purely creatures of the executive branch, even though they were created by Congress. And no mention whatsoever, even by the dissent, that this effectively puts out of business the protections that Congress wanted since the 1930s for federal workers and organized labor, period. And if you're a federal worker or organized labor, remember that at the midterms, which are coming up right around a corner, maybe a long corner, but it's right around the corner. Remember who screwed you in this case and in the administration when it's time to vote, and vote D all the way up and down the ticket. I'm Michael Popok. You're on Legal AF. Hit the subscribe button. Help us continue to, we get our march towards 700,000 subscribers, all because of you. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.